I am Michael Kessler, Associate Director of the Berkley Center, who's co-hosting this conference today. And I teach in the government department and in the law center with Marty Lederman, a class on law and religion. I'm delighted to welcome you here this morning. Our discussion here today is a part of a wider conversation about important issues: how our nation can deliver vital health care, control costs, and ensure individual autonomy, equality, and other cherished freedoms. Pursuing these social and personal goods through the Affordable Care Act has provoked one strong line of objections. As we heard earlier, some employers object on religious grounds to the requirement that they participate in providing coverage to employees for certain preventive services, such as contraception. Some have claimed that the HHS Rule forces religious employers into making an untenable choice between obeying the law and honoring religious obligations. Most notable in the controversy was Cardinal Timothy Dolan, Archbishop of New York and President of the U.S. Conference of Catholic Bishops. In response to the HHS Rule, he stated, quote, "To force American citizens to choose between violating their consciences and foregoing their health care is literally unconscionable. It is as much an attack on access to health care as on religious freedom. Historically, this represents a challenge and a compromise of our religious liberty," end quote. Likewise, President John Jenkins of the University of Notre Dame, in a letter to the HHS Secretary Sebelius in September of last year, urged a change over how the act defined which religious institutions would be exempted. And I quote, "According to the proposed definition, only those organizations that primarily serve persons who share its religious tenets count as religious employers. Although our Catholic convictions inspire and motivate the educational mission of Notre Dame and inform us about what we cannot ethically do, we nevertheless serve many others who do not share our Catholic faith. As Cardinal Keeler said of the Catholic schools in his diocese, we do not educate our students because they are Catholic, we educate them because we are Catholic," end quote. Our panel will explore the nature of these religiously based objections. How is a regulation like the HHS mandate a burden on religious freedom for some citizens? How do the objectors characterize that burden? Are there difficulties for making these claims arising from within the objectors' own religious traditions and institutions? What is the viability of the claim that the mandate requires individuals or entities to cooperate with evil in a manner that their faith forbids? Does compliance with the HHS rule prevent them from bearing witness or create scandal by conveying endorsement of activities to which they morally object? This is the basic inquiry we pose to the panelists. Now, so I do not miss anyone as we're going along, I'm going to actually take a moment to introduce each of them. Lisa Cahill is the J. McDonald Monin Professor in the Theology Department at Boston College. She earned a PhD from the wonderful program that I also got my PhD from at the University of Chicago, and works on the history of Christian ethics, Catholic social ethics, feminist theology, and sex and gender ethics, bioethics, and the ethics of war and peace. Among her many books and articles are Sex, Gender, and Christian Ethics from Cambridge in '96, and Genetics, Theology, and Ethics, an Interdisciplinary Conversation from Crossroad 2005. Patrick Deneen, formerly a colleague at Georgetown and now at that other Catholic institution, is the David A. Potenziana Memorial Associate Professor of Constitutional Studies. Patrick was the Sikopoulos Chair. He seems to be occupying chairs which are difficult for people to pronounce at panels.
And they're all in the Mediterranean.
Yes. He is the Associate Professor of Constitutional Studies at the University of Notre Dame. He earned a PhD in political science from Rutgers. His research interests include ancient and modern political thought, American constitutionalism, and Religion and Politics. He is the author of and editor of several books and numerous articles, including The Odyssey of Political Theory, 2000 from Rowman and Littlefield, and Democratic Faith, 2005 from Princeton. Kathleen Caveney's work focuses on the relationship of law and morality. She is the John P. Murphy Foundation Professor of Law and Professor of Theology at the University of Notre Dame. She earned a JD and a PhD from Yale. She has published over 100 articles and essays in journals and books specializing in law, ethics, and medical ethics, as well as a more popular venue in Catholic circles, Commonweal, where she appears on the masthead as a regular columnist. Her latest book, actually released yesterday, and we had a symposium yesterday at the center, is called Law's Virtues, Fostering Autonomy and Solidarity in American Society, and it's now available from Georgetown Press. John Langan is the Cardinal Bernardine Chair in Catholic Social Thought at Georgetown. He is also a professor in the Department of Philosophy and the School of Foreign Service, and a senior research fellow at the Kennedy Institute of Ethics. He is a Jesuit priest with a PhD in philosophy from the University of Michigan, and holds graduate degrees as well in classics and theology. His research interests include ethics and international affairs, just war theory, business ethics, human rights in theory and practice, Catholic social teaching, and the place of religion in liberal political thought, as well as is a specialist on the ethical theories of Augustine and Thomas Aquinas. He is currently working on a manuscript on the ethics of humanitarian intervention. We're happy to welcome John back after a year away in England. Finally, Robert Tuttle is the David R. and Sherry Kirshner Burtz Research Professor of Law and Religion at the George Washington University School of Law. After graduating from GW Law, he earned a PhD in religious ethics from the University of Virginia. He also holds a master's degree from the Lutheran School of Theology in Chicago. He teaches in the area of property, trusts and estates, and professional responsibility, as well as being a foremost expert in the law related to the intersection of law and religion. He's the author or co-author of numerous books, articles, and reports in the fields of legal ethics, church-state law, and faith-based organizations. So please join me in welcoming our panelists, and I'm going to ask Kathy Caveney to begin by setting up the question of what the claim to cooperation with evil is in the tradition in this conversation. And then we'll allow other panelists to present some opening remarks, and then we'll have a conversation.
Okay. Well, I'm going to give you a 3 or 4 minute introduction to what the Jesuit, I think it was Henry Davis, called the hardest problem in Catholic moral theology. Just for those of you who don't know a whole lot about Catholic moral theology, what happened is Catholics have a sacrament of confession where you go and you confess your sins and you receive absolution with the priest acting in the place of Christ. And the problem is, you know, that's great to say in theory, but how do you operationalize it? What are sins? How serious are sins? How do you think about sins? So people in the Catholic tradition, priests, you know, beginning before the Council of Trent, but definitely after the Council of Trent, began to write what are called manuals of moral theology. And what these are, most of them are in Latin. Even in the later ones, the bits having to do with sex are still in Latin. So there's an incentive to learn Latin. There is, generally organized according to the 10 Commandments, there's an investigation of, well, what counts as a sin, how to think about how serious the sin is, how to, you know, and how to guide priests hearing confessional. So that's why they're called manuals on moral theology. one of the great things about these manuals on moral theology is they do have to get into the mess of everyday life and have to deal not just flying over at the level of virtue and goodness, but actually look at actions in terms of, how they fit into a Christian life. That, I'm sure my co-panelists will talk, there's a downside to that too, in that they're negative and they can be legalistic, but one of the benefits of them are that they do get into the nitty-gritty of trying to live. And anybody who's lived with other people knows that one of the biggest problems you have to deal with isn't just, is this wrong for me to do myself? Should I do this action or not do this action? But should I help somebody else? Should I contribute to somebody else's decision or operationalizing of something that's wrong for them to do? So if you ever said, well, should I drive my great uncle with lung cancer to the CVS so he can buy some cigarettes? Well, it's not wrong for you to drive your brother per se, but it's wrong for your brother probably. It's a violation of self-care to smoke cigarettes if he's got lung cancer. That is a common question of what the Catholic tradition would call cooperation with evil. So by evil, we don't mean Dr. Evil. We don't mean some great giant, metaphysical evil. You mean under what circumstances is it permissible for you to do an act that contributes to the wrongful act of another? That's what cooperation with evil is. Every legal system has, some analysis of this, and I actually teach a course on complicity that looks at the Catholic doctrine of cooperation with evil, but also criminal laws on conspiracy and accessory liability. That's another type of cooperation with evil. So how does the tradition break up questions of cooperation with evil? Well, the first major distinction is formal cooperation versus material cooperation. And by this, they do not mean that the first is very dressed up cooperation going to a ball, and the other is just, informal cooperation. Formal cooperation means you are cooperating, you're contributing to the wrongdoing of another with the intention that they do that wrongful thing. So, if you drive your great uncle to the drugstore, to get that pack of cigarettes with the intention that he smoke them and actually, do this and harm himself because you can't stand him, well then, doesn't matter why, you're intending that he do the wrongful thing. If you contribute, if you sell somebody a gun, for example, not only knowing that they're going to shoot their spouse, but really intending that they shoot their spouse, that's another example of formal cooperation. And that is always wrong. Intending to further precisely the wrongful act that somebody else is doing is called formal cooperation, and it's never permissible. The harder questions come in the Catholic tradition when we are contributing some way, somehow, to the wrongful act of another, foreseeing, but not intending that they're going to use it to do something wrong. And that's called material cooperation, because you're not giving the form, which is in some senses the intention, but you're contributing the matter that they're going to use in doing their wrongful act. An analysis of cooperation with evil that's material cooperation with evil is a multifaceted test. We're all used to multifaceted tests. One of the factors is how much distance is there, and I'm using a non-technical term, between the wrongful act of the primary wrongdoer and the act of the cooperator. Sometimes there's virtually no distance whatsoever. So if you're the cooperator and you're opening the safe of the bank robber, who's really trying to rob the bank, you're opening the safe, you're taking the money out, you're taking it out. That's immediate material cooperation. And generally in the tradition, that's not permitted except in cases of duress. So if you've got a gun to your head and somebody's saying, open the safe and take this out, particularly if there's a grave violation of justice. And in fact, if it involves the taking of an innocent human life, even then you're not permitted to do it at all because of the harm. That's immediate material cooperation. Very hard to justify. All other cooperation is called mediate material cooperation. So there's some distance, some space in the time-space continuum between the cooperator's act on the one hand and the wrongful act on the part of the primary wrongdoer. And we assess this according to, or the tradition assesses this according to a number of factors. There's a continuum of proximate and remote. The closer you are as a cooperator in terms of causation, in terms of time, in terms of space, the harder it is for you as a cooperator to justify your contribution. Be interesting to look at questions of proximate cause in a comparative analysis and the notions of proximity at stake here. Another factor is the cooperation necessary or free? By that, they mean not free as in costly, but you ask yourself, can you stop the wrongdoing by not cooperating? All other things being equal, it's harder to justify cooperating with evil if your failure to cooperate would stop the wrongdoing. It's not the only factor. There is no only factor in this realm, but it's one factor. Very, very important, that's, I think, missed in this discussion, at least in the Catholic discussion, is what type of evil is at stake on the one hand, and what is the reason you're cooperating on the other? And different standards apply, depending upon that. But another factor as well is what's called scandal. This is, it's attached like a caboose to the cooperation with evil train. That would be the best way I would explain it. So you run your cooperation with evil analysis, but then you say, if I'm cooperating with evil, am I leading other people to sin? Scandal is not in the Roman Catholic tradition a view that, oh, I can't believe he did that. That's not scandal. Scandal is because of the fact that you're doing this, you're leading people to think that it's all okay. And in a way that you can't dispel by saying, no, I'm not really saying it's all okay. So scandal, a cost-benefit analysis, and distance are all important factors. A couple of other things I would say. The kind of cooperation that most of us engage in on a daily basis, it's impossible to avoid cooperation with evil acts, unless you manage to find a really perfect community. And most of us who believe in original sin don't think that, any one of us is free of sin. Or you manage to become entirely self-sufficient. And so it isn't a question of all cooperation with evil being sinful, far from it. We can't avoid cooperating with evil. The question is, when is it permissible and when isn't it? Remote material cooperation with evil, which is the kind we talk about a lot, is often said to be justified by proportionate reason. A decent reason, a good reason to go ahead and do it. That's the lowest test. That's the lowest kind of reason in the framework. The closer the cooperation gets, you required more grave reasons. Just a couple of examples. The moral theological tradition is very much like like the case law tradition. And there are examples that people use, that you can argue about, that the manualists have sort of analyzed and looked at in terms of whether or not you can do something. One of them, for example, a lot of them have to do with sex, actually. Can a taxi driver take someone to a house of ill repute? Or do you have to refuse? And the answer is, actually, it's very nuanced. If the cab fare says, well, can you find me a house of ill repute and take me there? No, you're not permitted to do that. I mean, because then you're kind of really, providing the matter. But if they give you an address, yes, you can. Interesting questions around the issue of abortion. Some of them are surprising to me, but the manualists, say that, that a janitor, for example, or a custodian, can work at a hospital where there are abortions performed, even if the heat that they're providing is going to heat the operating rooms. That's just pretty much of a straightforward remote material cooperation with evil problem. You may not be surprised at that. What is interesting is that a nurse, even in the tradition, in the manuals, is permitted to hand the doctors the instruments with which he performs the abortion. That's considered proximate, immediate material cooperation. I was surprised at that one. But the idea actually, I think, can be challenged in some way, because the idea is, well, the nurse is just handing people instruments without knowing what it is she's doing. So, the kind of, it's kind of got a sexist, the permission is almost based on a sexist presumption about what nurses are doing in these situations. So that's the general framework. When we get to the HHS regs and how it looks from my perspective as a moral theologian, it looks to me very much like remote material cooperation with evil. Well, where is the evil act? Well, the evil act is the woman taking this medicine, this prescribed thing, for the purpose of contraception. And I think it's worth noting that many women who use contraceptive medicines are not doing it for the purposes of actually engaging in contraception. So the wrongful act is there. It's quite remote because you've got then the doctor who is prescribing that to her for that, and then you're talking about a reimbursement that's even separate from that. So chasing out the kind of the causal connectivity, the time connectivity, and all of that is I think makes it very remote. It's also interesting to think about whether it's necessary or free cooperation. Arguably, the reason for justifying, including this within the healthcare benefit is that it's necessary. You're really kind of making women have access to this who otherwise wouldn't have access to it. But, the argument on the part of the people who oppose the mandate is, well, you can go out and get it elsewhere. I mean, that argument would make it free cooperation, which actually would make it, in some sense, more justifiable cooperation. So it's very interesting to see how that plays itself out. As far as I am aware, in New York and in California, the issue of contributing to healthcare plans that cover contraception has been looked at by a number of moral theologians, including some very conservative moral theologians, and was signed off on as remote material cooperation under duress. So it was considered permissible. Duress, justifies or excuses, permits behavior that wouldn't be allowed under other circumstances, as I told you before. I actually think what's at stake here in this debate isn't so much the cooperation with evil analysis in a narrow perspective. I don't think it's the contribution that matters, because it is very hard for me to distinguish that between paying somebody who goes out and uses their money to buy contraception, and other ways that it's covered. I think what's at stake here for at least some Catholics is their participation, their right to not normalize contraception as a morally, ordinary, accepted, and permissible act. That once it goes into the health care system as part of the benefit package, and that they're paying for it, it will be very hard for some of these institutions and entities to take what they believe is an important prophetic witness against what they would consider, some of them would consider, an aspect of the so-called culture of death, which is a broad way of understanding a struggle between two different ways of understanding family life and fertility. So I think in some ways the cooperation with evil analysis is important, but I don't think ultimately that's the ground that some of the people who oppose this are actually making their stand on.
Great, thank you, Kathy. Just two notes. Kathy got some extra time because she did the important pedagogical function of telling us about this notion of cooperation with evil. The second is Bob's nursing a back injury, so he's going to be up and down from sitting 2 hours in a seat.
Well, there's always that possibility.
That comes later in the panel. So now I'd ask Lisa if you could follow on that with your own sense of these issues.
Okay. Well, I'm not a lawyer. I want to say that right off the top. So I'm not really going to speak to the legal issues specifically, such as the first panel was addressing. So I am a Catholic theologian and a social ethicist. And so that's the perspective that I'm taking on these questions. And the point that I want to make is not so much about what the conclusion should be, but rather what is the nature of a Catholic approach to issues like these. And the really basic point that I want to make is that the way Roman Catholic tradition looks at its ethical positions, so Catholic social teaching or natural law moral theology, that's different from the way more biblically based religious traditions or even U.S. law looks at the moral positions of religions. So for Catholics, our moral positions and our positions in political advocacy are not just based on therefore is not a free-floating personal or group option outside the bounds of justice or the objective moral order. So in the documents that defend, for instance, religious freedom, the main one is a Vatican II document called Dignitatis Humanae. There's also an encyclical of John Paul II called Redemptor Hominis, in which he comments on religious liberty as defined in Dignitatis Humanae. And both those documents use terms like, and I'm quoting directly, true justice, public morality, the public order as the minimal standards of public morality enforced for all. Those are from Vatican II. John Paul II talks about religious liberty in terms of what is authentically human, what is justifiable on the basis of experience and reason, and specifically says that it does not rely on, quote, purely religious grounds. So when we look at these issues of religious liberty, healthcare, or any other social issue, we have to remember that individual and institutional conscience and liberty exist in a social context and have to be exercised in view of the dignity of the person and the common good. So again, natural law or some modern iteration of that is the basis of Catholic social teaching and Catholic political participation. So looking then at the principle of cooperation, that too, well, first of all, it's applied on the basis of a lot of relative judgments, such as Kathy was just talking about. You know, gravity of evil, proportionate good, sufficient distance between the cooperator and the objectionable activity. And again, those judgments have to be referred to the dignity of the person, the common good, and the necessary requirements of the public order as, again, Dignitatis Humanae, the minimum requirements of action that apply to all. So we cannot avoid issues like how grave is contraception? How great is the good of universal health care or the provision of basic preventive care? How remote is Catholic participation? Those all have to be estimated. We don't have a mathematical formula to give us a conclusion. We have to acknowledge gray areas, and we have to balance all of these against each other. So for Catholics, it is not or should not just be a matter of, is this a sincerely held religious conviction? We also have to look at things like a couple of terms that came up in the last panel, the common good, or non-discrimination, or is contraception, or should it be, a basic health care benefit, or when is it? What kind of contraception? So questioners brought up natural family planning. Should that be included? How about male contraceptives? Should those also be included or not? And again, you know, is there a variety of reasonable ways of gaining access to what might be considered basic care? So I would say that simply to claim religious freedom from what are arguably requirements of the common good without giving any substantive argument as to what those requirements are or should be, in fact, itself leads to scandal, because it creates the impression that Catholic moral and political positions are simply the products of irrational religious dogma.
Right.
I think that's a sellout of our natural law moral tradition, and in fact, it's a capitulation to the moral relativism that Catholic tradition ordinarily decries. Finally, then, Catholics at least, I would say, need to put this whole debate back on the footing of universal coverage and just, fair, and reasonable definitions of covered benefits. And there is a discussion that can reasonably be had. As we have that discussion, Catholics should be leading the way to build bridges across the divisions and the lamentable, paralyzing polarizations that now plague our political discourse. As Melissa Rogers was saying at the end, I think the Catholic Church and other religious institutions and also government agencies need to be prepared to negotiate, to reasonably accommodate, to compromise, and to find whatever areas of flexibility there are.
Thank you, Lisa. Patrick.
I think I'm going to stand, but not due to a back injury, but I don't want to put myself to sleep in addition to you. I would say it's nice to be back, but I successfully avoided coming to the law center for 7 years, and so, alas, my unbroken streak has been broken. I'm going to try to use technology. We'll see what happens. So the question that's been proposed as a prompt for our discussion and for our panel were the following. What do you make of the claim that the HHS rule imposes a burden on religious persons and/or institutions? How do you characterize that burden? Number two, how do you characterize that burden? And how do you think religious actors on the one hand and government policymakers on the other should respond to the claim by some that there is a burden imposed? Now, I too am not a law professor, and I don't teach a course on along the lines of that by my new colleague, Kathleen. But it's not merely avoidance that I want to change the approach or the questions. Now, as I suspected based on preliminary email discussion by the members of this panel, a good amount of our discussion already has been focused on parsing and analyzing the claims of burden, of distinguishing between forms of formal and material cooperation with evil, of direct and indirect forms of cooperation, the kind of painstaking examination of ways that the implementation of the HHS mandate is or could be structured to assuage concerns by religious organizations that they would otherwise be complicit with actions that go against their faith commitments. But I think, however, the way that these questions have been framed, that we miss the actual set of questions we should be asking. And that these questions, in fact, are rather easy to answer. And the time that we spend attempting to parse out these issues diverts us from what I think is the more important question that was not asked in the prompts. It seems to me that the answer to the question of whether the imposition of the HHS mandate, whether it represents a burden upon religious organizations and even individuals, can be easily answered in the affirmative. In fact, it seems to me there is no debate on this point, at least of which I am aware, although probably some people do. Both the administration, which authored and promulgated the mandate, and a number of religious organizations, including the Catholic Church, have agreed that it represents a burden and agree that an exemption is warranted. What is not agreed upon is what constitutes a religion and what constitutes a religious organization and who gets to decide. That is the real debate that we should be engaged in. The government has already acknowledged that the mandate requiring religious organizations to provide contraception, to be complicit in the provision of abortifacients, sterilization, that this warrants a mandate. It has already been granted to religious organizations, as the government has laid out, that meet a four-part test. Those tests, the parts of those tests are as follows. 1, its purpose is the inculcation of religious values. 2, it primarily hires persons who share the organization's religious tenets. 3, it primarily serves persons who share those tenets. And 4, it is a nonprofit organization of a type described in sections, I won't give you the sections of the IRS code, but there are sections of the IRS code that are relevant. That is, religious organizations which primarily focus upon the inculcation that hire and serve co-religionists have already been granted an exemption. The government recognizes that that the mandate constitutes an imposition upon their religious belief. Religious organizations, however, that do not meet all of these 4 tests are not likely to be granted an exemption. This includes many Catholic and non-Catholic institutions, including the university where I teach, the University of Notre Dame, which has filed a lawsuit, obviously against this, against the mandate. Sorry, my technology is acting up on me. I'll make a printout next time. For the purpose of the government's distinction of who receives the exemption of the burden imposed by the mandate, institutions like the University of Notre Dame and this institution are not religious. The government thus recognizes that the HHS mandate represents a burden upon religious organizations. Moreover, it actually recognizes that the distinction it is drawing here is one that is problematic enough that it deserves special notice of its exceptionalness. As articulated in the advance notice issued by the U.S. Council of Catholic Bishops on May 5th of this year, and I quote, the administration claims that, quoting the administration, the 4-part definition of religious employer is not intended as a precedent for any other purpose. The USCCB then notes, and I quote again, this disclaimer raises a question. If the administration does not consider the definition a suitable model for future regulation or legislation, then one wonders why it considers the definition suitable for a nationwide contraceptive mandate. The Church here, as articulated by the Council of Catholic Bishops and many of its institutions and organizations, argue that this 4-part test constitutes an incorrect and illegitimate and even an illegal definition and narrowing of what is a religious institution, and moreover that the state is seeking to define something over which it has no legitimate knowledge or understanding. Again, to quote the advance notice by the Council of Catholic Bishops, quote, the definition of religion creates an impermissible gerrymandering in which some religious organizations are considered religious enough for the exemption while others are not. Reduced to its simplest terms, an organization is religious in the administration views if it is insular. We are free to worship God, but not to serve our neighbor. Even Jesus would be deemed to have been insufficiently religious to qualify for the exemption because he fed and clothed people of many different beliefs. And so this narrow and cramped view of definition of what constitutes religion in the eyes of the government is the crux of the matter. It recognizes that the mandate does constitute a burden upon religion, but it limits what it considers to be a religious institution essentially to privatized forms of worship. It does not recognize in particular the historic commitment of my faith, the Catholic tradition, and that of many of the world's faiths in understanding its ministry and faith commitments to engage with the world, in particular through its ministries of education, of caring for the poor, of the healing of the sick, and of the comfort of the dying. Thus, in his letter of this last May of this year, President John Jenkins of Notre Dame, who, as we should recall, graciously and controversially invited President Obama to deliver the graduation address and receive an honorary degree from the university, in spite of much criticism in 2009, and where President Obama articulated his commitment to respect for conscience of religious believers, explained to the Notre Dame community and beyond the grounds for the lawsuit against the HHS mandate that had been filed on that day, which he said was filed neither lightly nor gladly. And I quote Father Jenkins, "This filing is about the freedom of a religious organization to live its mission, and its significance goes well beyond any debate about contraceptives. For if we can see that the government can decide which religious organizations are sufficiently religious to be awarded the freedom to follow the principles that define their mission, then we have begun to walk down a path that ultimately leads to the undermining of those institutions. For if one presidential administration can override our religious purpose and use religious organizations to advance policies that undercut our values, then surely another administration will do the same for a different set of policies, each time invoking some concept of popular will or the public good, with the result that these religious organizations become mere tools for the exercise of government power, morally subservient to the state, and not free from its infringements. If that happens, it will be the end of genuinely religious organizations in all but name," end quote. This then is the crux of the issue, whether the government determines what a religion is, which of its institutions are deemed sufficiently religious to warrant protection from the encroachments of the state. This very institution where we gather today has always described itself as a religious institution. Its current president, John J. DeGioia, in his inaugural address of October in 2001, spoke of his great pleasure, honor, and delight to be assuming the leadership of a Jesuit university that, quote, "seeks the integration between university and church." He noted with special insistence that the mission of Georgetown from its very inception was to serve all people, not merely Catholics. Yet in part because of this very commitment that derives from our tradition, according to such people as Kathleen Sebelius, whom Georgetown honored by inviting it to speak at its graduation ceremony last spring, Georgetown is not a religious organization. I can only wonder why Georgetown has also not filed suit. In that same address I quoted earlier, President DeGioia quoted from Father Eric Priswara, a Jesuit, who wrote that he understood, quote, that at a Jesuit university, we live on the borderline of where the church meets the world and the world meets the church. However, according to that definition of religion, as invoked currently by our administration, that is not a church. It is merely an organization that does things while claiming to be a religion. It seems to me, whatever our political stripe, all of us should be concerned by this unprecedented incursion of state power into defining something it does not have the legitimacy or knowledge to do. And I would hope and encourage programs and institutions like this that were founded in the Catholic tradition, not only to seek to find ways that we will accommodate ourselves to it, but if necessary, resist it. And I thank you.
Thank you, Patrick. John.
Oh, okay. Well, it's a pleasure to be part of this discussion, since I think it's very appropriate for a very distinguished law school, which is an element in a Catholic university, to foster a kind of interdisciplinary discussion of a matter of pressing public concern. I will take satisfaction in perhaps being necessarily interdisciplinary, since again, I'm not a lawyer, and I think about these things in broadly historical terms as a philosopher. And I think that the long history of religious freedom is something that can be understood in rather different ways. I'd propose, just as a thumbnail sketch, drawing a contrast between two different ways of understanding religious freedom. One which is particularly prominent in the Catholic tradition, which is that it is the libertas ecclesiae, the freedom of the church, which is particularly concerned to protect the church against incursions from the state, which affirms the autonomy of the church in regulating its own business, pays respect to the self-understanding of the church, all things which I think were neglected in the HHS regulations. This is not simply a matter of the self-interest or self-protection of the church. It's also a very important contribution to the shaping of Western civilization. This was a point that was insisted on long ago by the distinguished English historian Lord Acton, in which he saw this as a major step in the development of liberty in the West. The affirmation of the church as a separate institutional realm, not deriving its authority or legitimacy from the state or from the imperial regime. So this is a sense of religious freedom which the church has been happy with over a long period of time, which it vigorously defended in some of the great controversies of the Middle Ages with the kings of England and the German emperors, and which it insisted on, say, as against the efforts to establish state authority over religion, which were at the center of the English Reformation. There is also another way of understanding religious freedom, which is more broadly resonant within American political culture. And that is what I would call a Protestant individualist understanding, in which the primary subject of religious freedom is not the community of believers, but the individual, whose conscience is to be respected and who has a kind of sacredness in relationship to not simply political authority, but also religious authority. And this has been a very powerful strand in American religious history, and I think also in the shaping of public argument. And it's very often what non-professionals will leap to as, in effect, their first understanding of religious freedom. It's clear to me that the Catholic hierarchy, down through the centuries and at the present time, is more comfortable with religious liberty in the first sense than it is with religious liberty in the second sense. And there's a strong tendency within Catholicism to interpret dissent from or divergence from church teaching not as a protest of conscience, but as the product of an ill-formed conscience, and in need more of re-education rather than of affirmation and protection as the exercise of a right. So there will be a certain dissonance that's likely to arise, not simply in the way the arguments are used, but in the public perception of what the arguments mean, because of this ambiguity in a quite central term. The church did make very significant steps toward accepting religious liberty in the second sense in the 1960s. The encyclical of John XXIII, Pacem in Terris, which has a quite impressive listing of human rights, which is identical to a very large extent with the Universal Declaration, but much more extensive with regard to what were called social and economic rights, and which in fact is the basis of church acceptance of universal health care, and which meant that the church, while highly critical of this aspect of the Affordable Health Care Act, was broadly supportive of the objectives of providing universal access to health care. So, and this was one reason why there was so much internal tension within the Catholic community in the later stages of the passage of the bill in 2010. The church in general, after a period of enthusiastic endorsement of human rights, which reflected partly the church's reaction against the totalitarian regimes of the mid-20th century in Germany and Russia, but also the struggles of the church, particularly in Latin America, with regimes which emphasize national security over human rights and over political freedom. This has in some ways become obscured by a more wary attitude has developed, because the language of rights is immensely attractive and powerful. It's an instrument of mobilization, and also for bringing a lot of issues that are disputed in the political order into the judicial realm. And so that there's a human rights culture which, in effect, moves issues from the level of popular discontent through political organization into judicial resolution. And this is, in effect, expected in many political movements in our society and in other societies around the world. And the church has had, to put it mildly, a distinctly ambivalent relationship to a lot of the demands made by the women's movement and by gays and by gays and lesbians. So that there's been a distancing between the human rights community and the Catholic community, which is quite different. The relationship is quite different in character from what it was when the issues of the day were the Pinochet regime in Chile and the apartheid regime in South Africa, where there were lots of political alliances and mutual support, which now would be very difficult to duplicate or even to sustain. So that I think it's important to recognize that some of the key terms and attitudes in this area of discourse have significantly changed. They're not, shall we say, fixed essences which we can nail down once and for all. And I would urge some of my Catholic colleagues to be more ready to acknowledge the historical character of these affirmations and the way in which they're developed in response to the changing historical experience of the church in many different societies. There is a certain tendency, perhaps especially in American law for understandable reasons, to be concentrated on what is happening in this country, which is obviously an immensely important country. But a lot of these tensions are paralleled in European discussions, and the church takes very seriously its presence as a worldwide organization, and that will not be responsive simply to pressures arising from political struggles and legal struggles in this country. I would add one footnote to what my friend Kathy Caveney was saying about material and formal cooperation. Interestingly, when the question of voting for pro-abortion candidates was raised in a European setting, some very high authorities in the church made exactly the distinction between formal and material cooperation, that it was unacceptable for Catholics to vote for pro-abortion candidates if they were voting for them precisely because they were pro-abortion. But if this was simply part of a larger political decision in which one in effect was saying, I don't agree with the candidate's views on this question, but I think that the candidate offers better possibilities for our society and is a more appropriate leader overall, then that would be something legitimate. That did not figure prominently in the analysis of this issue presented by the American bishops. There is, besides the complex history of this question in Catholicism, there's also a genuine international diversity present within the church. Thank you.
Thank you.
Thank you all very much for just making a wreck of what I had planned to say, because I have so many things now to think about and respond to. Thanks especially, though, to Marty and Melissa for putting this together and starting the conversations off in the spring that have led to this, and to the Berkley Center folks as well. I am, in some respects, the outsider in this, not just because I was standing against the wall, but I'm a Lutheran with distinguished Catholic moral theologians here, and I'm going to talk a little bit about Catholic moral theology, but in the end, despite our Augustinian family that we're part of, you will sense some differences, and I'm going to launch right in to one of those differences at the beginning on the question of what is religion, right? I mean, Patrick makes this a central part of his argument. What is religion? And the error here he claims is that the state is defining religion, and this is something that you hear quite frequently as an objection, and I think it's misplaced because when the state defines religion, it is not defining it as a matter of the internal life of the religious community. The state doesn't define religion in order to tell you which aspects of your work count as religious. So it is perfectly plausible for a group of people to form a commercial enterprise. There is a Luther bar, I think it's called Luther Tavern, out in Washington State, and they turned an old church into a bar. And there is the congregation sold the property to a group of younger members in the congregation who said, we're going to keep some of our identity. We see this as an act of worship. And I say that is a religious work for them. We have a theology of vocation that even supports it, and a love of drinking beer, which we all share. But the government doesn't have to say that that is religion in order to validate that for the people who are engaging in the exercise. And I think that is a crucial distinction for us to keep in mind. The government defines religion in an inordinate number of different ways. And it is not being inconsistent when it does so. It defines religion for the purposes of broadcasting. It defines religion for purposes of different portions of the tax code. It defines religion for purposes of individual religious liberty claims. It does so in ways that are a matter of political prudence, not in order to make a theological judgment about which are inside and which are outside. The fact that people may take the messages is not the fault of the government, that it's the fault of their own faith development. And we, within the churches, need to do a better job of telling people, look, the government may not think these things are places of worship, but when our folks, I serve on the board of Lutheran Services, so I get to give this speech all the time, right? When our folks go out and do ministry, and I call it ministry, when they go out and do ministry, that is just as much the heart of the church as word and sacrament ministry. The fact that the government doesn't see it so is purely irrelevant to that issue. That's number one. Number two, I am, to put it mildly, not a fan of the Religious Freedom Restoration Act. I think it's incoherent. I think it's constitutionally infirm if it's not incoherent. And so I am proceeding under, I would say, duress, because that doesn't quite capture it. But I'll play the game of sincere, substantial, and all that kind of stuff, because that's the way the rules go. But I think it's important to set this conversation in the context of some history. And it's in the history of deep suspicion of the administration from the Conference of Catholic Bishops that was, I hesitate to use the word, but that was affirmed summer before last in the administration's decision to go with EEOC. And I'm looking at Marty, but I'm not blaming Marty. In Hosanna Tabor, when the administration said that it was fully within the competence of courts to decide whether a ministerial employee is adequately performing their job. That, to me, is as close to an infringement on the liberty of the church as you can get, and yet the government said no problem. So I think that there are many other things, but we're already operating in a zone of suspicion here, and this just plays into that story. So I think some of that story is important. But the other thing, cutting back in the other direction, that's important to keep in mind is John raised the idea of the liberty of the church, the autonomy of the church. And I am a church lawyer. I represent church institutions, and anybody that has been a church lawyer in my lifetime has defended sexual misconduct cases. I cannot say the words church autonomy without not just embarrassment, but a deep sense of grief. I find them almost vulgar, because we, the lawyers 20 years ago, made those claims, that it was impossible for the victims of sexual misconduct to sue the church because we were immune with respect to our internal operations. Sue the priest, right? We don't care, but not the church. We're not responsible to civil authority. We have to regulate ourselves. And that's appalling. I mean, I defend those cases, but that's appalling. Why is it appalling? Well, it's because we do not operate in a zone of separate spheres. We don't operate in a world in which the church has its independent sovereignty. We operate in a world in which the government recognizes its own limitations over certain aspects of life in part for all of the liberties we talk about, but also in part to guard against the kinds of totalitarianisms that John identified when he talked, right? The idea that the government is not a church. And so part of remembering this is also remembering not just Argentina, but also Spain. And the concerns about the church itself claiming the instruments of state authority to impose its views. That is the flip side of the liberty of the church, which is the liberty of the state, or the liberty of the polity from being a church, should it choose not to do so. In this context, the state has chosen not to do so. The state has chosen not to do so, and so religious communities, religious organizations that are religious in their own self-understanding and are appropriately understand themselves in that way, have claimed that they are not. And so we have a matrix for then deciding whether those claims are appropriate. I'll finish in just a second. Sorry, Michael. That first, is it sincere? I think it's not very useful to have a conversation about sincerity because I don't know what it means. I think this test is incoherent, by the way, but I'm going with it anyway. Is there a burden? Well, Patrick talks about, right, people recognize that there is a burden. Maybe that the question with these cases is, can the determination of whether there is a burden be made by somebody who is outside the faith? Which is why the Lutheran here gets to ask this question. Am I competent to ask the question about whether there is a burden on Catholic institutions? If I am not competent to make that decision, because that is a decision that is solely within the community of those who are under the teaching authority, the pastoral, I don't mean authority in the bad sense, but the pastoral supervision of the Bishop of Rome. If I'm not competent to do that, then RFRA itself is incoherent, because basically the government has to take the word of every claimant that comes in that they have been burdened, and their burden is one that then generates an obligation on the part of the state to prove by the strictest terms that it had no other way of doing this. And as Justice Scalia said in Employment Division versus Smith, that is a recipe for anarchy. I'm getting my Lutheran side out here, by the way, but that's okay. That is not the way you run a polity. So there has to be some capacity to make secular determinations about the substantiality of the burden. Otherwise, the test is incoherent. And if it is, then I think we are back with where Kathy was to begin. And I think Kathy's analysis fits mine, right? We're talking about remote, immediate cooperation. Just want to end with one last word. Starting with Kathy, brought me back 20 years ago to feelings of deep inadequacy. I went on the teaching market a year after Kathy, you know, kind of similar profile, JD, PhD thing. People said, you're good, but you're no Kathy Caveney.
Well, thank you, Bob. So I want to circle back to some conversation that happened earlier today and link it. Marty put together this very helpful law and regulations handout, and on page 4, you'll find the second HHS religious accommodation advance notice of rulemaking, and then towards the bottom, and this is currently the case, there is, the bottom paragraph reads, the government agencies have also represented in an advance notice of proposed rulemaking that during this safe harbor period, they will amend the preventive services coverage regulations to further accommodate non-exempt, non-grandfathered religious organizations. Perhaps the government would, for example, require health insurance issuers to offer health insurance coverage without contraceptive coverage to religious organizations that object to such coverage on religious grounds. So one of the questions that has come up in the public debate is whether or not the advance notice by HHS after the initial blowback and intense debate in some ways could potentially solve the claims that this represents somehow cooperation with evil. And now some have accepted that. Melissa Rogers on the panel this morning suggested that that does solve the problem for some organizations. But I wonder about the strong claim that some have made that this in fact is, you know, a shell game, is sort of really still having religious organizations contracting for these services.
Who's this to?
Kathy?
Well, I mean, whatever the law does on this matter, that is one thing. I think Catholics have to have a conversation in Catholic terms about what's at stake here. And, you know, I don't see how, I mean, I've been very impressed with the Obama administration rules on a number of fronts. One is, or the proposed rules. One is, and I think this point, you know, Bob, you made, you know, there is no essentialist definition of religion. Law doesn't deal in essentialist definition. It's functionalist definitions for a particular purpose, not for a particular purpose. So the idea that the government is labeling you as religious or not religious by virtue of how it's framing an exemption from a particular law doesn't strike me as the right understanding of how the law works in the American context. The revised, you know, notice of rulemaking says, you know, we are not saying to you Catholic universities and Catholic hospitals that you're not religious or that you're any less religious than these other institutions. What we're trying to do is come up with an exemption that balances a range of rights. The way I see what's at stake here, the most frustrating thing, you know, for me in this whole discussion is I think we Catholics have lost a lot in the way we've talked about this. We have been the people who have said, you know, rights have to be understood in the context of communities. They can't be framed as trumps. And yet we are putting forth the notion of religious liberty as a trump without analyzing how it fits into other contexts and other communities. We are the people who say the golden rule, you know, is the first material principle of the natural law. Do unto others as you would have them do unto you. How are we looking at the claim from the other side? I haven't seen a lot of Catholic doctrine taken seriously, the claim on the other side. And I do think there are religious liberty claims, as Father Langen pointed out, on the other side, on the part of employees. One of the things we could ask is, what are the basic benefit packages? What kinds of claims of health care should you have available to you no matter where you work? What are the basic human rights, basic rights in the context of healthcare that travel with you everywhere? If we frame this discussion that way, and not just in terms of religious liberty, we're going to come up with, I think, a broader discussion, as Lisa would point out. And I haven't seen much of that. So I'm afraid that in pushing our claims of religious liberty, which I'm not saying are not legitimate or don't have some aspects of it, but the way we're doing it, we're sacrificing so much of how we as a tradition bring forward and model ethical discussion. And that's what wearies me most of all about all of this. That wasn't an exact answer to your question, but sorry, that was my own statement. Yeah.
Patrick, does that address and in some ways cure some of the concerns you have about the conversation? You wrote a very compelling piece early on in this conversation in which you pointed out that the reaction by the bishops and others on the right, the bishops and persons on the right, as well as the bishops, had in some ways adopted the very privatistic language that of religious liberty and individual autonomy that you found troubling on the HHS rule itself.
Well, no, and actually, I very much agree with the concluding remarks of my colleague in pointing to the way in which this debate has been framed in highly individualistic terms. The invocation of the rights that we are accorded, of conscience. All of these terms, of course, don't need to be construed or understood as individualistic. And I think the Catholic tradition, as I think everyone here has acknowledged, except for Robert, begins with a deep understanding of the relationship of these concepts, which have been largely adopted in the liberal parlance in an individualistic mode, how they are embedded in a deeper context that considers community, the common good, and the natural law. But at the same time, I note that Kathleen began her remarks by suggesting that this is how the law works in the American context, that the law doesn't give you another way to talk about this. And this was really my complaint. And so my complaint is probably just fundamentally systemic, and I may not be all that helpful to you budding lawyers out there, that the way in which these debates are framed within the American liberal context necessarily force you into that language. And what I was trying to point out in that piece was that in some ways this becomes a self-defeating argument, even for those who want to stand for the place and position of the church, that they are forced into a language that they don't initially accept. And so my strong pushback in my comments is that obviously in part making an argument for what we might consider to be forms of corporate rights, institutional and associational rights, which seems to me is embedded in our Constitution, but which is often neglected or downplayed in preference to individual rights. And this is something that I think has been a great witness of the Catholic tradition within the American tradition, which it was not initially included in the founding, but which it, I think, has offered a great succor and assistance. And finally, I guess in regard to the specific question on the panel, while I think, and I understand that the way, again, looking at the framing argument, that the way that this argument is framed is that these are institutions just like other institutions that go by the name of university and hospital and social services, that are employers and have employees. I think it is fundamentally necessary to understand that these institutions were not founded on the same grounds as their secular peers and counterparts. They were founded as parts of the church, as part of the church's ministry. And I think we fundamentally misunderstand these institutions as fundamentally indistinguishable from their secular peers if we don't acknowledge that that was the reason for their existence and continues to be the reason for their existence. So, yes, it's very difficult, as Robert points out, and we do have to engage in some casuistry in sort of determining and weighing claims about what is and is not religious. But it seems to me that one of the things in a liberal society that comes first is a great deference to that claim, and certainly given the long historical presence of these institutions and of this church in this country, that claim ought to be given great deference, and more than I see being given right now.
I just wonder, though, and Michael referred to Patrick's piece that's included, I think, in materials that are available for all. It's a very, very fine piece in trying to shift the conversation. The problem is these things are being litigated in courts right now. And the questions you raise are questions of political prudence, not jurisprudence. Because the form that they take is really a question of whether or not, as a matter of political prudence, the institution should have been given greater deference, which means a more expansive view of protections afforded to them. And there are wonderful arguments you can make in political prudence for why that kind of respect is appropriate and justifiable. The question, though, is whether once the polity, right, acting through its appropriate forms, has decided otherwise, what is the church's response at that point? Right?
Well, I think what's happened is filing lawsuits.
Right.
And and one has to do that, again, as Kathleen suggested, in the way in which the law works in the American context. So you appeal to that language of rights, to that language of conscience, and to that language of liberty, all of which have a Catholic definition, and the only point I was, or at least one of the only points I was trying to make in that piece, was that necessarily gets heard in an individualistic mode in the American context.
Right.
And I wanted to alarm my co-religionists and fellow travelers and sympathizers that this was a danger.
But it seems to me then that what we're really talking about is not material cooperation in that sense, but more is the 1 Corinthians 8 point about scandal. You have become a stumbling block to your fellows because you have not done all that you can to distinguish yourself from the sinful act, right? Which is, I mean, there are so many layers of complexity to this when you unwind it, but if you look at the Catholic litigation, I don't think Lori is here, so I'm not going to attribute this to her, but it's certainly not the way Beckett would frame this. But the lawsuits are not about material cooperation. They are the church doing everything that it can do within the realm of political prudence defined most broadly to make clear the extent to which it opposes being linked with the act of contracepting, and to the extent that abortion is included. All right, I think that's right, and I think that's appropriate as a matter of Catholic moral theology, right? You can do it, and the church does it, recognizing that it incurs other costs by being misunderstood in its language, but nonetheless, its witness, its political witness is carried out through litigation. The problem, though, is when you try to interpret that political witness in the language of substantial burden,
Right.
it is not a recognizable burden under any conceivable version of RFRA.
If that's the case, well, okay, under RFRA, I was going to follow Kathy's analysis of this and concluding that this does not constitute a form of complicity with evil. If that's the case, why is not this panel about why exemptions should not be extended to churches as has been defined in that four-part test? Because if it's the case that this does not constitute complicity with evil, then why has this exemption been granted in the first place?
Because there are politically powerful groups that would have raised even more.
Then we're not actually talking about what we're talking about.
Well, I mean, the only thing you might say is that you could make an argument that the complicity with evil analysis is actually different in the cases of small churches, than it is in the case of big healthcare institutions, because it's such a separate fact and circumstances test. And one of the questions that comes up in the cooperation with evil case is sort of the legitimate expectations of the people you're engaged in. So in terms of say a taxi driver would have more of a duty to drive people certain places than say you would as a private person. So you could argue that if you're a multi-million-dollar or multi-billion-dollar institution that generally presents itself as more or less like, and it's true that Georgetown and BC and Notre Dame present themselves as still rooted in the religious tradition, but we also present ourselves at the same time as being part of the broader academic culture and as offering places to work that are similar to that. The same thing on the hospitals. You could argue that under those circumstances, we've got a much more pluralistic kind of engagement, that fairness to your employees and reasonable expectations of the people you're dealing with actually shift the cooperation with evil analysis. And I think I could make that argument if I had lunch.
One doesn't want to get between a determined lawyer and her lunch. But it does seem to me that this problem has also been exacerbated within the Catholic community by the development of the notion of intrinsic evil, which makes the problem of cooperation more intense. I mean, there's a lot of, this is an area in which, shall we say, matters that were being disputed in the theological community were given a very definite shove in a clearly defined direction by John Paul II. But somehow the idea of compromising with or being implicated in intrinsic evil had a kind of emotive quality and also political power. That, for instance, one thing that I think surprised a lot of people was when the bishops decided to take a stand not merely on opposing abortion. In a sense, politically, that's very familiar territory. I mean, that's something like the territory that was governed by the Hyde Amendment for a long time, and which obviously, given the development of a comprehensive healthcare system, had to be reconceived and reformulated. But why take on abortion? Why take on contraception? But contraception is, in terms of the theoretical approach of authoritative moral theology, papal moral theology, in the same box, in the sense of being clearly forbidden and as being labeled intrinsically evil. So the Catholic, many of the Catholic participants in this whole process obviously are deeply affected by that. And so that I wouldn't want to have us lose sight of the importance of the cooperation with evil argument, even if we don't find it satisfactory.
Well, thanks to each of you, and we have about 15 minutes to open the floor to questions. I ask that you do keep them brief so that we can get to a number of them. And We'll have Marty and other people walk in with
I'm going to take the organizer's prerogative of asking the first question.
Absolutely.
And then pass it around. And I'm standing here between Kathy and lunch. I'm not sure that's a great idea. But we have 15 minutes. And I think Kathy's onto something, that I think at least many of the organizations and other employers here are objecting not because of any real belief in material cooperation with evil, and I say that being someone even further outside than not having the Augustinian sources at all.
They're there for you.
They are. They're always there. And I think that's right. I think what's going on, and Patrick, I don't think the administration or HHS has conceded that there's a problem of cooperation with evil, even for the churches. What HHS has said, and what's very interesting if you read the rule and the definitions, is what they were trying to accommodate is a different concern, which is the ability of the church and other organizations that only hire from within to have more control over what their employees do in a situation in which the employees have, in theory, more often volunteered to be subjected to those rules of the church and won't as frequently be objecting to the norms that their employer is imposing upon them. It's not a theory of accommodating cooperation with evil from the government side, and I think Kathy's right that it's not for many of the employers anyway. I think you're right that it feels more like, the more one presses on this, that the real concern is that being required to make contraception part of these packages for health insurance, your words were, normalizes contraception, or maybe, perhaps suggests approval or endorsement of that sort of thing, and denies them the ability to engage in prophetic witness, is what you said. And I think that's going on. I think the reason those are not the arguments being made in public, and certainly not in litigation, and maybe this is the tension that you were all trying to bring out, is that's a losing argument in litigation, right? Being required to do this, now your prophetic witness is even stronger. You can inveigh against it, you can complain about it, you can pay the fine and engage in civil disobedience, right? What more prophetic witness is there than that? And why should the government accommodate your ability to be a prophetic witness to the wrongfulness of what you see as the wrongfulness of the government? So those arguments, which I do think are motivating at least a large measure of this, have to be suppressed in the legal and public debate, and it's turned into this argument that seems to us outsiders quite unpersuasive about proximate material cooperation with evil. And I just wonder whether those discussions are going on within the church and these organizations, and whether, if there is this sleight of hand going on, whether that's troubling or not to folks within, or maybe we're underestimating the number of these organizations who do think, contrary to what you've described, Kathy, that it is proximate material cooperation with evil.
Remote.
Remote. Wow, okay. I'll get all my adjectives in.
So I think Bob
Go ahead, Lisa.
Remote material cooperation with evil, or even proximate, isn't necessarily ruled out by the church to begin with. But I think the more basic problem here is that 98% or something of Catholic women use contraception. And generally speaking, members of the Catholic Church and other Catholic entities do not see contraception as, say, intrinsically evil. So there's a debate about that in the Catholic Church, but I think it's the minority view that it has the level of significance as being attributed to it. If you talked about abortion, that would be a different matter, where there would be much more consensus among Catholics that that's very problematic. And I think, one thing that is simply going on here is that the bishops are moving over to the ground of religious liberty because they don't want to have to engage the moral arguments for and against contraception, because even within the Catholic Church, that is a losing battle. But by the same token, I would say they are really short-selling the basis of the Catholic moral tradition and the basis on which it tries to make any number of other public arguments, such as the morality and justice of access to basic health care for all. And what they don't want to engage is whether contraception should be part of that or not. But I'm not sure you can avoid that and still have the moral tradition intact. And I do think, as people were saying on the first panel, that there should be room for compromise, but the limit to compromise is the common good. That's the whole thing. That's the Catholic position. So to the degree that these services that some might find objectionable can be funded and provided in another manner, I think that that should be acceptable on Catholic grounds. I mean, yes, to be worked out exactly what will the arrangements be. But I really strongly feel that this whole shift to religious liberty is taking the Catholic moral tradition to a place that is inimical to the history, the tradition, and the very foundations of that tradition. It's not just based on religious faith. It's based on human nature, the common good, human dignity. What does a good society need? And yes, there will be debates about what that means. Like abortion would be a much bigger issue where you would find many more Catholics in consensus that an open right to abortion does not serve the common good, the dignity of the person, and so on and so on. Okay, but on the issue of contraception, I think the approach to this that we're seeing is avoiding a discussion because it's a losing battle, but it is also a disservice to the very basis on which we claim to make our other moral, claims or agendas or, yeah.
Just briefly, a point that Marty didn't bring up, but is something that if I were representing the government in these cases, one of the things I would ask is why the organizations don't simply exercise their existing power under Title VII to say that anyone who purchases contraception, uses contraception, can be terminated.
Right.
And you agree when you sign on that this is a matter of Catholic doctrine, and nobody does that as far as I'm aware.
Well, Bob, but that's because the vast majority of these organizations are not willing to
confine
their employment to co-religionists.
But if in fact this is such a grave sin that the organization would fall into it by this 3 steps removed engagement, why don't they take what seems to me the much more direct step of telling their employees that as a condition of employment there, and it's just that I'm not using this as the end all. I mean, it's an open question, right? Is there a reason internal to the tradition that this option, other than just a matter of who you can hire, that this option is not one they would exercise?
We have a question from Father Orsi.
My name is Father Les Orsi, and I am teaching here at the Law Center. Now, I have more questions than answers, but let me begin with a point of information, whether or not the government may or must define what is religion. For some years, I have been part of a group regularly consulted by the IRS, Internal Revenue Service, and they receive requests in great numbers from various groups that claim to be a religion, and they want tax exemption. And those requests come them very frequently. They have no choice. Therefore, there are cases where the government is perfectly entitled to make a judgment what is or what is not a religion. It's another question on what criteria. But just to give you an example, I remember a case, settlement by several hundred people. It was in the Midwest, and they ordained all grown-up males as ministers of religion. The women and the children were the community. And the whole group claimed tax exemption from everything because they were religion. And the IRS had to answer. So these are down-to-earth necessities. So let us be very careful about setting general principles. Now, that leads me to another much more serious point. And it's this. I think in some way, we may be falling into a pattern that is now the pattern of political, even religious discourse in the nation. We try to resolve issues by analyzing them and then setting up oppositions. I basically agree that this whole issue is that of material cooperation in a pluralistic state and all that. It's a prudential issue. There is no absolute rule, and we shall never find one. But on the other hand, precisely for that reason, the only way to solution is getting together, talking to each other, trying to understand each side the other, and then each side making compromises. Because we are not hurting some kind of direct principle. And that understanding is a sort of art. We have to work for it. Let me just give you an example. We are discussing whether or not, from Catholic point of view, this is permissible or not permissible. But at the same time, I am myself a Catholic, and I say, I agree, it would be remote material cooperation. But you have to understand also that the Catholic Church understands itself to bear witness about a higher quality of life, higher moral standards, which may be an ideal, but it's part of the vocation of the Church. And therefore you can see that on the one hand, conceptually, there is plenty of room for compromise. On the other hand, if I may say so, the heart of a group of people are crying out, but in some way I would like to witness something else than what is minimally permissible. And that's an ideal. And our community, our society, more than ever today, needs this kind of, shall I say, example or movement or whatsoever. So, frankly, I do not see any other solution than in one way or another getting together and with the necessary humility, if you like, but also compassion for the other side, on each side, talking to each other and coming to a compromise that cannot be found by precise conceptual analysis. Another point, in a way, I regret that we focus so much on contraception. Even in the Catholic Church, if you like, it's a funny expression, there is a hierarchy of evil, and contraception is not at the top of it. Murder is, and I'm talking church doctrine, and I know what I'm talking about. Therefore, at least in a way. So, therefore, again, the main purpose should be how can we promote this kind of coming together, understanding, and then how far we are able to make compromises. So that's about, I have much more to say, but I think I should just thank you.
Thank you, Father.
Thank you, Father.
Thank you, Father Orsi.
Let's try to take
Marty, Kathy has a response.
I mean, I admired and learned so much from Father Orsi over the years. You know, thank you for your remarks. The only thing that I've noticed in the tradition kind of shifting over the years, and I think right after the Second Vatican Council, right after Humanae Vitae, the prohibition against contraception was challenged. There was a majority report that called for the change in that position by you know, a number of distinguished moral theologians. So at that point, disagreement about contraception was framed as a disagreement about a remote application of the principles of natural law. And you know, you could think, well, there's a hierarchy of truths, you can disagree about it. What I wonder if is happening among some Catholics, including some of the bishops that are most concerned about this, is they kind of relaunched the tradition like a Batman franchise with Veritatis Splendor and Evangelium Vitae, and that presented contraception in a rather different way as the so-called, I call it the gateway drug to the culture of death. You know, that there's been a shift in the presentation, especially not among all Catholics, not among maybe Catholics on this panel, but in the discussion, in the way they're framing contraception, if that isn't part of the problem.
Thank you, Kathy. We have time for one or two more questions.
John.
And
Yeah, very quickly. I've found Les's remarks eloquent and moving as I would expect. In some ways, they may seem banal, but they're not banal in the context of contemporary Catholicism, because there's a strong tendency towards the development of an intransigent faction, figuring that people who believe that when confronted with a culture of death or with a society which accepts intrinsic evils, resolute opposition is the appropriate way to renew the church, to focus its energies, and to create something more like a Christian republic. This is a difficult project even to get on the table for reasoned discussion, but it continues to have an appeal, and it involves, frankly, a movement away from the kind of position staked out in Vatican II. And that's a very important challenge to the self-understanding of the Catholic community.
Great. We have time for one more
I'm sorry,
question.
can I just jump in?
Hang on for a second, and then I'll let you respond. We have time for one more question after Patrick responds, and I'd like to ask if there are any students that are in the audience. We haven't heard a lot from the students, so raise your hand, and you'll be found. Patrick.
I guess just one brief remark from the intransigent faction. It strikes me, one of the things that Kathy said at the end of a previous remark, that it's precisely the institutions that have been pluralistic, open to the world, seeking an engagement with the world, that they, to the extent that they are going to, and so I think about my current institution, are going to resist this, are being forced into an untenable position of whether or not they're going to remain in that stance. So it seemed to me that actually the way in which this mandate has been posed without exemptions is actually forcing institutions into intransigence that they otherwise don't want to embrace. So it seems to me that rather than sort of placing the blame on this faction, it's more important to realize that this is a kind of battle that was not wanted or welcomed.
If these two students could both ask a very quick question, we'll get you both in.
My name is Kieran Ravel. I'm a senior up at the main campus. In order to recover the language of common good and dignity of the human person, perhaps as Professor Cahill was talking about, as sort of all of you touched on, does anybody in the panel see any prospects for the conversation or the focus moving away from the rights talk, if you will, where it is now, to draw on what Paul VI was saying in Humanae Vitae about what contraception is doing about the common good? He speaks prophetically about divorce, family breakdown, da-da-da. Helen Alvarez is great on this. Do you see any chance for that kind of conversation to come out?
And the second question.
I'll do my best to be brief. Mr. Deanan, you mentioned 3 key points, which I completely agree with, but I wanted to draw them to a logical conclusion that seems obvious to me. You mentioned reframing the question in the sense of what is a religious organization and who decides. That, I think, is critical point number 1. You mentioned the foundation of certain entities like the university, like Catholic hospitals, as wings of the Catholic Church in and of themselves at their beginning. And then you expressed a concern with entities sliding towards being religious only in name. And I think all 3 are critical. But doesn't that line draw the line at an institution like, say, we might have mentioned an HVAC company, which 48 years into its foundation has added religious precepts to its Articles of Incorporation, roughly when the Affordable Care Act was passed? Isn't that drawing the line at a different place? And I think at a significantly more compromising place. But doesn't that principle basically pass judgment on the claim of the for-profit corporations?
Well, actually, I think, in our conversation really has been, you're right about that, has been focused on religious institutions. And here, as you rightly point out, I wanted to press back against whether or not the analysis of complicity is the appropriate way in which to frame that. I do think, however, that it is appropriate to frame this, and this question appropriately is one to frame in terms of non-religious institutions and organizations. And here, if the question had been focused on that, I think we would be having a different conversation. So I'll have to punt that to a future to a future panel. I would say just the very brief time that remains to me that another panel that could be constituted and organized, and a very interesting one, is picking up on something that Marty mentioned, which is that it seems to me that I'm hopeful that these law cases get underway and concluded soon, which will never happen in this world, because I'm hopeful that the actual conversation and discussion that we've been having here will be the discussion that certainly we have among Catholic and beyond, circles and beyond. And that's not being had right now precisely because of the language that you're forced to engage in these conversations. But I would put on the table, and it would be an interesting question and perhaps an interesting panel, what happens if the church or these institutions loses these cases? And this is something that Marty raised. And one of my concerns is that after all of the stance that's been taken by members of the church, by leaders of the church, saying that this past this point, this cannot go, that when the prospect of fines presents itself, they will find a way to do the thing that they say they can't do. And is it actually the case that this is a bright line that cannot be crossed, and we either will pay the fines or we will not pay the fines, and what will the state do then? That seems to me to be an extremely important question that we're not talking about, and as a member of the church, I would like to see the church talk about. The other day, John Garvey, the president of CUA, in a faculty meeting said, we will have to pay $62 million a year in fines for not complying, and implied that they will not comply if they lose these cases. It will put these institutions out of business in short order. Maybe not Notre Dame immediately, but within about a decade.
Are we at 8.4?
We got a few bucks in the bank. But at any rate, it seems to me that the logical conclusion of this should be a discussion, what happens if these cases are lost? And this position is actually one that cannot be crossed.
So on this question, I can be a bit prophetic. There are 30 cases filed in almost every circuit in the country. And
somebody's going to lose.
I almost guarantee there are going to be some where the plaintiffs win and some where they lose. And it's ultimately going to be resolved by the Supreme Court. I think that's a fairly safe prediction.
So Lisa, you wanted to respond.
I just wanted to say very quickly to the gentleman in the sport coat there, because you addressed my comments, and I think your comment should be very well taken, because what you were really talking about was having a discussion about contraception on the basis of really whether it does or doesn't contribute to justice and the common good and human dignity. And I definitely think, without being absolutist on either end, it's always justified or never, that there is a reasonable discussion to be had about the hookup culture, about the purposes to which contraception is put. And the 98% of American Catholics who use birth control don't really have access to that whole conversation because it's an all or nothing game at this point. And so I think what you said should be very well taken. Like, let's look at the human effects, the human reasons to use it or not use it, which is really putting it in the justice and common good categories that you introduced your remarks with. So that point was very well taken.
Well, thank you, each of the panelists, for this wonderful, reasonable discussion.